Hello, welcome to your academy if you are new, and welcome back if you're part of the family already. So, this is the chapter 8 of business law. Okay, this is chapter 8 of business law, and in this chapter 8, we'll be talking about contract of employment. Okay, we'll be looking at contract of employment. That's the topic, contract of employment. And because it's just, I think, in the material, the fifth edition material for ATS, I think it's I think it's just 5 pages, 5 or 6 pages, 5 or 6 pages. So I've prepared it um just 3 pages here. So we'll just go through chapter 8 in 3 pages. So stay tuned. This won't take long. It's just a short, very short um topic. So contract of employment. Let's quickly look at the introduction. Right to work is a fundamental human right. Okay, from chapter 1, we say we have constitution, we have human rights. Okay, in the constitution, fundamental human rights is in the constitution, and right to work is part of the fundamental human rights. So, and the reason is that work is the main means of sustenance for man. Okay, work is the main means of sustenance for a man. All right, man, man in this context, I'm not just referring to like male, human, generally speaking, especially in economies, especially in economies with no unemployment benefits. There are some economies, there are some countries that you have unemployment benefits. If you are not working, the government will be giving you some amount of money. But we don't have it in Nigeria. Okay. So we don't have it in Nigeria. So it is very, very important. It is very, very crucial. Work is very, very important because it is what you need to do to get something to, pay your bills and everything. So employment is based on contract. We are still looking at introduction, okay? So employment is based on contract. It could be expressly stated or implied. Okay, it could be expressed or implied. But it's still based on what? Based on contract between employer and employee. Alright? It's still based on contract between employer and employee. So both parties have rights. Both parties have what? Rights and duties. We have rights and we have duties. Duty is what you need to do. Okay? Duties is the consideration. Alright? Uh is the consideration of the contract from both parties. Okay? Then right is what they are like your how will I put it? Right, like things you still need to enjoy. Okay, things that cannot be taken from you. Okay, that is um things that you need to benefit. All right, as an employee or as an employer. You get it now. So rights and duties. So since every contract must end, in this same material, we look at ways employment contract ends. Okay, we look at the termination, dismissal, okay, redundancy, and remedies for breach of what? Breach of contract. Okay, so that's what we have. And the reason is that employment is a relationship based on agreement, rights, duties, and rules. No matter the job, it's based on agreement, rights, duties, and rules. So, and all of these are part of the things that you find in the contract. Okay, so that's why we need to understand what, because you are into business, as as an employee, you're still working in an organization. Okay, so there are agreements, right, duties, and rules that needs to be in the contract. Okay, so that's what we want to discuss in this video. Now let's move on to section 8.2, which is nature and formation of contract of employment. Nature and formation of contract of employment. Nature and formation of contract of employment. So, nature now. Let's start with nature. Nature of contracts. At common law, it is assumed that both parties are equal and freely agree on the terms. Okay? And this idea is called freedom of contract. But in reality, this is often not true. Okay? We need to note that. But at common law, it is assumed that both parties have equal what? Equal um rights. Or let's say both parties are equal and freely agrees on the terms. Alright? So this idea is called what? Freedom of contract. That's what the idea is called. Freedom of contract. But in reality, this is often not true. It's not always true in reality. Most employees have less bargaining power. Alright? Most employees have less bargaining power. And I'll give you an example. Okay? Now, you know that there is no job. And because of the fact that the employer knows that you really need this job, they will tell you this is the amount that they can pay. But because you need the job, then you have to do what? You have to take the. Does that mean that there is um freedom of contract? No. It's still freedom of contract in writing, because they'll tell you read it before you sign. But do you have a choice? Do you understand it? So that's why in reality it is often not true, because most employees have less bargaining power. Can somebody tell you, I'll only pay you 150, and you say no, 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 no. The worth of this job in other country is 700k. That's what I'm going to collect. If you're not paying that, I'm leaving this place now. They will just tell you to leave, because the job market, even when you get to the organization, you see many people that are there for the interview. So even that reality will make you realize that, oh no, I need to calm down. I need to calm down. Do you understand what I'm trying to say? So that's the reality. Employers usually set the main terms and give employees take it or leave it. Okay? And this creates a relationship of employer authority, employee subordination, which is fact. Okay? Take it or leave it. We are only paying 250k. If you are not taking it, leave it. There's somebody out there. After you leave now, you will see that somebody will come in and take the job. That's just the reality. So this relationship can lead to abuse. So laws and trade unions work to protect and improve workers' rights. There are laws and trade unions set to protect and improve workers' rights. Okay? So that's for the nature of contract. Now let's move on to formation of contract. General rules of capacity apply in employment contract. What do we mean by general rules of capacity? Um, who can do the job? Okay. General rules of capacity apply in employment contract. Labor Act allows infants and young persons to be employed on daily basis, but with restrictions. Okay, they also allow young persons and infants uh, to be employed. When we say infants, we are not talking of day old, 3 months, 6 months, 4 years old. No, 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 no. We are talking about at least 12 upward. We have looked at the age range in chapter 2. Um, okay, and when we're talking about special courts. So, if um, Labor Act allows infant and young persons to be employed, okay, on daily basis, but with restrictions. So, these are the restrictions. A young person must not be employed at night. That's number one. Not on public holidays, not in underground operations, not on machine or shipping vessels, not against the wishes of parents, very important, or guardian, if communicated to employer. Okay, so these are the restrictions. Even if a young person, is to be employed. All right. Another thing is that women can enter into employment contracts. Okay, women can enter into employment contracts, but the Labor Act give them protection. So what are the protection for women? Number one, there's something called maternity leave. We have maternity leave. That is, women are entitled to 6 weeks before delivery and 6 weeks after delivery. Okay, 6 weeks before delivery and 6 weeks after delivery. Now, this thing, I'm not saying that's how it is in organization, but this is the minimum. There are some organizations that give 3 months. There are some organizations that give 6 months. Okay, but this is the minimum. All right. So protection during leave. There's protection during leave. They cannot be given notice of dismissal during maternity leave, even if they stay longer due to illness. That is to protect them. Restriction on work. Women cannot be employed on night duties or underground work in mines, except in management roles, without manual labor, or in health and welfare services. Okay, health and welfare services. Okay, so those are the rights, those are the protection given to women. So this is the end of the first page. What is the takeaway here? Employment is based on a contract between employer and who? An employee. That's the first one. The second one is that both parties have rights and duties. The third one is that most employees have less bargaining power. Terms are often fixed by employer, which is what? Which is true. Infants, young persons have special protection under Labor Act. Likewise, women are protected through maternity leave and restriction on certain work. Termination, dismissal, and redundancy are ways a contract can end. Remedies exist for breach of the employment contract. We have not talked about these last two in detail, but we made mention of them in the introduction section. So let's move on to page 2, which is the second to the last page, because we only have 3 pages for chapter 8. Okay, so we want to now look at the rights of the employer and the employee. Rights. Let's take a look at the rights first. What are the rights of the employer? Okay, so both employer and employee have rights under a contract of employment. Okay, both employer and an employee have rights under a contract of employment. So we want to take a look at the first one, which is right of an employer. The employer has the right to employ workers, okay, to discipline workers. When we say discipline, we are not saying cane them, or but in other ways, like, okay, you come late to work, this is the deduction from your salary for coming late. That's a form of discipline, not the extreme discipline, okay, of now beating or something like that. No, 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 no. You are not allowed to, as an employee. You don't have the right to do that. So there is discipline. Discipline workers is part of the right of the employer. Transfer workers is part of the right of the employer. Okay. Promote workers is part of the right of the employer. Terminate employment is part of the right of the employer. The employer controls how the business runs. So the employer can decide business targets, product or services, price, expansion or closure of business. So they have the they can decide that. That's what employer can do. So let's take a look at that of the employee. So the employee has the right to number one, right to work under satisfactory, safe and healthy environment, healthy condition. Okay, that's the right of an employee. If you think that the office is hot, you have the right to demand for something to cool the temperature. Okay, you have the right, and if you are not given, you can sue the organization. You have the right. It's your right, something that you should benefit. Okay. So number two, you have the right not to be discriminated against at the workplace. Okay, not to be discriminated against at the workplace. The word here is discrimination, discriminated. Okay, you are not to be discriminated against at the workplace, no matter who you are. Okay, so far you are being employed, you are not to be discriminated against at the workplace. You are not to. Okay, no matter what is wrong with you, you are not to be discriminated. Okay. The third one, you have the right to equal pay for equal work without distinction of any kind. Right to equal pay for equal work without distinction of any kind. Without distinction of any kind. Equal pay for equal work. Equal work. Okay? Don't just take equal pay and leave equal work. There is equal pay for equal work without distinction of any kind. So let's say we are being employed as an accountant, okay, in an organization, same day, okay, and we do the same job. If I'm collecting 250k, you should be collecting 250k as well. All right, because we do the same work. But let's say the organization now say, okay, if you can do this extra job, you have this bonus. If that is calculated to your pay, and maybe I now hear that you earn 350k in total, and I approach the HR for um for explanation, it must be stated. I must know that, okay, the extra 100k in your own payment is due to other things that you do that I'm not doing. So there is equal pay. You have the right to equal pay for equal work without distinction of any kind. Lastly, you have the right to rest, leisure, and reasonable limitation of working hours and period of holidays. Okay, you have the right to rest, leisure, and reasonable limitation of working hours and period of holidays. And lastly, you have the right to form or join a trade union of your choice. Okay, You have the right to form or join a trade union of your choice. Okay. Number 6, you have the right to be trained and retrained for the development of your skill and receive information relevant to your work. You have the right to that. Okay. You have the right to be trained and retrained for the development of your skills and receive information relevant to your work. Very important. Those are your rights as an employee of an organization. Okay? Remember that. All right? Now, we want to move on to duties of an employer and employee. Duties of an employer and employee. Duties of an employer and employee. So, we have talked about the rights of an employer and employee. So, we want to look at the duties of an employer and employee. So, there are duties imposed on the employer and employee, that is worker, by virtue of their contractual relationship, contractual agreement. Okay. So, we want to take a look at the first one, which is duties of the employer. What are the duties of the employer? The duty of the employer is to provide work for the employee as agreed in the contract. Okay. Number 2, pay wages and remuneration regularly according to the contract, either weekly, fortnightly, or monthly, but not longer than monthly. Pay weekly, every 2 weeks, or monthly, but not longer than monthly. Number 3, it is the duty of an employer to provide a written statement of the terms of employment. Provide a written statement of the terms of employment within 3 months after the employee has resumed duty. Okay. Number 4, to provide a safe system of work, a safe system of work, which includes proper appliances and plants, supportive, competent staff, proper work system, effective supervision. It is the duty of an employee or employer to provide that. It is the duty of an employer to pay expenses reasonably incurred by the employee in the course of duties. It is the duty to pay expenses reasonably incurred by the employee in the course of duty. So let's say you are part of an auditing firm, okay, and you have been assigned to have a physical assessment in an organization that the firm has been, contracted to audit. Now, you now spent or you fuel your own car to get to the location. Okay, it is the duty of the employer to pay for that expenses. Okay, it is the duty of an employer to pay for that expenses reasonably, so far there is evidence of what? Of payment. Remember, you are an accountant. There is evidence of what? Of payment. So, it is also the duty of an employer to compensate injured employee or the relatives of deceased employee who suffer mishap in the course of duty. In the course of duty, there is an organization, a manufacturing company I once heard of in Ikeja. They produce, um, I think, pipes. Yes, and I heard what I heard. I didn't witness it. I heard it that one of their staff That is, someone working with the machine, had an accident which resulted to one of his hand being cut off. Okay, and they paid him money, and stuff like that. So it is the duty of an employee to compensate injured employee or the relatives of deceased employee. Okay, because if the person is dead, do you want to go and pay the dead person? No, you compensate the relative, okay, of the deceased employee who suffer mishap in the course of what? In the course of duty. In the course of duty. It is also the duty of the employer to grant agreed leaves, okay, and at least one work free day per week. Okay, one work free day per week. That is Sunday, Monday, at least one work free day per week. And also, lastly, it is the duty of the employer to pay redundancy when applicable. We'll get to redundancy in the last page. But there's something called redundancy, okay? And we are going to explain it better in the last page. So, but when there is redundancy, when redundancy is applicable, it is the duty of the employer to pay for redundancy. Now, what is now the duties of the employee? We have talked about the duties of the employer. We want to look at the duties of the employee. It is now the duty of the employee to exercise his professed skill, okay, and diligence. Okay, it is the duty of the employee to exercise his professed skill and diligence. Now, note, not more commitment than disclosed to the employer. Not more commitment than disclosed to the employer. If you say you only know how to use Excel. If peradventure after the employment you are now trained on QuickBook, use QuickBook. Do you understand what I'm trying to say? But if you said what you can use is Excel and you are now asking for Sage, you know that is doing more than what you said you want to do, because it is based on what you said you can do. That's why they are paying you the money that they are paying you. All right. So yes, you can now do more to to get promotion and stuff like that. But it's not as if it will now be part of your duty to do more than what you stated. Do you understand? So number two, it is your duty as an employee to perform the duty for which you are employed and other related duties. Okay? For duty that you are employed and other related duties. And other related what? Duties. Perform the duty for which you are employed and other related duties. Number three, obey lawfully. Oh, sorry. Obey lawful and reasonable orders of the employer. Lawful and reasonable orders of the employer, provided they are within the terms of the contract and not illegal or contrary to public policy. Okay. Number four, render your services personally and not delegate your duties without the consent of the employer. Okay. Render your services personally and not delegate your duties without the consent of the employer. You are being employed as an accountant, as a junior accountant in an organization. The first day you showed up, Tuesday you showed up, Wednesday you showed up, Thursday we saw somebody else, and the person now said, I'm representing so so. Ha, so as in, you understand my point? So you are to render your service personally and not delegate your duties without the consent of the employer, even in a case where somebody needs to fill in for you. Though accounting in accounting you can't do that anyways because of disclosure policies and stuff like that. But in a case where maybe in other kind of businesses that somebody else can represent you, it has to be what? It has to be with the consent of the employer. Number 5, keep secret your employer's confidential information and trade secrets. Okay? To the duties of the employee is to keep secret his employer's confidential information and trade secrets. Very important. Don't disclose. Number 6, serve the employer faithfully and not put himself in a situation where his interest will conflict with that of his employer. No. Alright? So those are the duties of the employee, the duties of the employer, and the duties of the employee. So now let's look at the key takeaways for page 2. Employer has rights to manage and control the business. Okay. Employee has rights to fair, safe, and respectful treatment. Employer must provide work, pay regularly, and ensure safety. Employee must work diligently, obey orders, and be loyal. Both sides have duties to maintain a healthy working contractual relationship. Okay, very important. And lastly, we want to look at termination of contract of employment. So, termination of contract of employment, which is the last page for chapter 8. A contract of employment can be terminated for the following reasons. Number 1, RIP. I know you can see that, which means death, frustration as well as operation of law, natural events such as death. Number 2, compulsory winding up of the employer's company. Okay, compulsory winding up of the employer's company could also result into what? Termination of employment. Dissolution of partnership in a case of personal service can result to what? To dissolution of what? Resolution of termination of employment. Number 4, compulsory conscription of the employee during hostility or war. Okay, prolonged illness of the employee. Prolonged, that's the right word. Prolonged illness of the employee. And you have mutual agreement as when ad hoc job is completed and on happening of some event or contingency or by affliction or of a term certain. Okay, mutual agreement anyways, just mutual agreement. So by mutual agreement, if we conclude this project, you guys will not work for me. So it's a contractual, like contract staff. When you say contract staff, 3 months is because we have much demand, so we need contract staff for this project, for this high demand. Just 3 months. That's contract staff. Okay. So, and it's a mutual agreement. After 3 months, you yourself, you know that you are no more working in the organization. They can now give you another offer. Okay, they can even start give you a permanent offer. But mutual agreement, you know what it means. Then you have termination of the employment by the employer or employee after due notice. That's the last one. After what? Due notice. There's something called due notice, and we are coming to that. So, um, what are now the remedies? If a contract of employment is breached, the following remedies are available. Okay. Number 1, damages. This is the normal remedy. It is monetary compensation paid to the injured party. That's number one. Okay. Number two is reinstatement. Reinstatement means the employee is returned to the position he occupied before with all the benefits attached. This is in the case of unjust um, you know unjust breach of contract of contract. Okay. Okay. Unjust termination. Let me just put it that way. Unjust termination. So that's, there's a court case, and the law said, okay, let this person be reinstated. So reinstatement is part of the remedies for breach of what? Contract. So important note, court are reluctant to order reinstatement because the position may already be filled. It may create a hostile working environment. Reinstatement is often impracticable, but um it's part of the remedies in the case of wrong or unjust termination of contract. Okay. Okay. So that's for the remedies. When it is common, when is restatement common? Restatement is common when it is usually granted. Restatement is usually granted where a public officer was removed without just cause. Okay. And I think you know the reasons why restatement in in private organizations is kind of very hard, because immediately they have somebody else who is doing the job. Organization work have to, the work process have to continue. So there's somebody already on the job, and that person cannot be taken off like that. The person will also sue. So it's going to be like a circle of restatement and restatement and restatement and stuff like that. So and also in a case where it is enforced, that is, restatement was actualized, there's going to be hostile working environment. There's going to be hostile working environment. You just see that people, so the boss that is laughing with you will frown, will not, all those kind of stuff, and be waiting for the is you know the legal way to to terminate the employment. That's just what it's going to do. You understand? So that's for and lastly, reemployment. Reemployment is the last remedy, which is the worker may be employed again in the former job or in another suitable job on similar terms and conditions. You know, reemployment. When they sack you here, you go and look for another job and you are being employed in that organization. That's for remedies. Okay. Now, I want to look at the last one, which is redundancy. What is redundancy? Redundancy means the loss of job because of major changes in the business. Loss of job because of major changes in the business process. Okay, it happened in commercial bank some years back. Like, a lot of people were just sacked. Their employment were terminated. So this is caused by redundancy. Is it Now? Let me explain redundancy. Redundancy means that, let's say, uh 10 people used to do the work of ATM before, but when ATM came, they don't need the 10 people again, so they need to cut them down. That's redundancy. Major changes in the business process is what led to maybe like 7 people being sacked, because their work now, the work has been simplified. Just one person can program, fill in the cash and stuff like that, instead of 10 people counting and dishing out cash. You understand what I'm trying to say? So um that's a very good example of redundancy. So it is the severance of the legal relationship between employer and worker. Now, what is the result? Worker becomes unemployed or suffer reduction in terms and conditions of employment. That's what happens in a case of redundancy. Now, what are the employer's duties during redundancy? Okay, there's what we call written notice. You can't just wake up one Monday and say, um you other seven people that are dishing out cash, you have to submit all the company's assets with you, and we are so sorry to tell you you can go. No, it's not done. There have to be written notice. Okay, due to this, um this is what is going to happen, and not just to you as an employer, because redundancy leads to massive um termination of employment. Okay, so there have to be written notice to chief labour officer and the trade union concerned, not later than 3 months before the actual effect of that um that termination of employment. Do you understand? There have to be written notice to chief labour officer and the trade union concerned, not later than 3 months before. Number two, give important information. Okay, that is, give reasons for termination, numbers number and categories of workers likely to be affected, period within which termination will be carried out. All of this information is part of the things that will be in what is written, uh what part of what is written as notice to the chief labour officer and the trade union and any other concerned parties. So, and also to consult the trade union, and the consultation is to discuss measures that will avert or minimize termination, mitigate adverse effect on workers, and find alternative employment before the effect of the redundancy. Do you get it now? So what happens after the redundancy? These are before the redundancy. So after the the termination of employment, there is something called redundancy pay. And what does that mean? It means it is a compensation money paid to workers whose employment is terminated due to redundancy. Okay, so that's redundancy pay. Just like, I know you can figure that out. That's what redundancy pay simply means. Compensation paid to workers whose employment is terminated due to redundancy. Amount and terms of payment are subject to negotiation between employer and worker slash union representative. So that's that about chapter 8. Um, what are the key takeaways? Employment can end in several ways, and we've made mention of a couple of them. Notice is important in termination. Damages are the normal remedy for breach. Reinstatement and re-employment are other remedies. Redundancy is caused by major business changes. Employers must give notice, information, and consult trade unions. Redundancy pay is paid as compensation. Those are the key takeaways for chapter 8, page 3. So that's that for chapter 8. If you like this video, please, if you like what I'm doing here, please subscribe, share, and give it a like so that the algorithm can share it, show more people who might benefit from this video. So thank you, and I'll see you in chapter 9. Bye.